It don't matter. God, I mean, where did, we are ready. If, yeah, Representative Rich is here to present. Let's see, I don't have my glasses on. House Bill 497. Those that were members prior may remember this bill. Governor Deal vetoed it. We thought it was a good bill. He didn't. So we're going to one more shot at this thing. So Representative Rich, now this is a hearing only, but we want to go ahead and get started on this bill. It's an important piece of legislation. So Representative Ridley, Rich. Ridley's over here with another bill. Are you ready to present the bill? Okay. Let me see. I think we've got you on.
Okay, thank you, Mr. Chairman, members of the committee. I bring to you today House Bill 497. I'm working from LC 41-1833. This bill is the exact language that passed the House and the Senate last year and was ultimately vetoed by our very traditional lawyer, governor that we had at the time. The bill reflects language that was negotiated between interested parties, and I have met with representatives from the banking industry regarding this bill this session, and they are comfortable with the language and will not be opposing the legislation. House Bill 497 is essentially another step in the modernization of our trust code. It provides for the allowance of a self-settled spendthrift trust. That's something that under traditional tort law was not allowed. However, it is becoming the norm. The trend across the country is to allow self-settled spendthrift trusts. In fact, states bordering ours, including Tennessee, Virginia, and even Mississippi, have passed legislation allowing these. We have residents of Georgia who are maintaining these trusts in other states. There's also some interest in maybe acquiring some of the assets from some Floridians, because Florida does not have this legislation yet. This basically is another asset protection tool, but the traditional occasions for piercing the trust, including tax issues, child support, tort, criminal restitution, those are still allowed. In addition, in order to ensure fairness among the banking partners that are interested in this bill, any individual who uses or lists assets on a disclosure with a banking institution, those assets cannot then be put into the trust. If so, then the trust will be pierced and the assets will be at risk. Does anyone have any questions?
Are you at the end of your presentation, or do you have more?
That's all, unless someone has questions.
Are there any questions? What's that number? I can't. Right there we go. I think that's right. Wait,
Hello.
Vetoed this, and I was wondering if you could give us any insight about any public statements he made about why he vetoed the bill.
Well, it's my understanding that his opinion of trust law is that trust law is sacrosanct and should remain the way it is, but the truth is that there is a trend in modernizing the trust code, and this is a very common change that's being made in other states. It's my understanding that our current governor believes that this bill is another piece in our putting business first in our state, because it will increase business in the trust industry and in banking as well.
Okay. One more question, do you mind? Are you concerned with how this may affect the debtor-creditor relationship in making sure that debtors fulfill their debts?
Oh, no, not at all, because as I mentioned, if someone completes a due diligence or an application and they list assets as collateral or as a lot of times it's not necessarily collateral, but high net worth individuals will list their assets in a disclosure in a business transaction, those assets cannot then be placed into the trust. So there is no danger there whatsoever.
Okay. One more, if you don't mind, Mr. Chairman. Okay.
That's why we're here.
Yeah.
Keep asking as long as you have questions.
You know, I'm not a litigator. Maybe, I don't know if you are. So, you know, I try to think about who might be adversely impacted by this. I certainly support, you know, a friendly business environment, making sure Georgia continues to be the #1 state to do business in. But I worry about future litigants and their ability, you know, to, you know, be made whole through the litigation process. You know, if the person who owes that obligation, you know, is, for lack of a better term, hiding assets. So, you know, as an attorney, I'd love your thoughts on that.
Well, first of all, this is not a tool that anyone would use to place all of their assets, because any individual who puts an asset into this tool will lose control over it. It will have to be managed by a professional trustee, and there will have to be another beneficiary designated such that the trustee will owe a fiduciary duty to the person, the settler, as well as another beneficiary. So no one would put all of their assets into this. This is a really big deal. And also your concerns about being made whole as a litigant, well, remember taxes, child support, torts, and criminal restitution judgments. Those are all occasions to pierce the trust.
Thank you very much.
Mm-hmm.
Yes, sir. Representative Allen.
Thank you, Mr. Chairman. I have a real easy one. Just for my own, just to do a little research, what was the bill number that was vetoed by Governor Deal?
I'm sorry?
Do you recall the bill number?
I think in looking at my notes, it was 444, 441. Okay, 441.
Thank you.
Representative Frazier, did you have a question?
Yes, sir. Thank you, Mr. Chairman. Can you explain to me, first of all, I'm trying to understand the meaning of spendthrift trust, and I see your definition here. I just need it in layman's terms. And also, my second question is on line 23 to 26. I need you just to give me a brief synopsis of exactly what does that mean.
Okay. First of all, a spendthrift trust is a trust where assets that are within that trust are protected from judgment or seizure by creditors, unless it's the situations that I was just describing. Mm-hmm. So that's a spendthrift trust. And now you were questioning lines 23 through 26? Mm-hmm. Is that what you were questioning?
Yes.
Okay. So just so you know, that is the code as it exists now, except that the word "the" is just being changed to "such."
So actually, a person that has a spendthrift trust, a beneficiary, it's a shall not.
Right. Right. It says a beneficiary shall not transfer an interest in a trust in violation of a valid spendthrift provision, and except as otherwise provided in this code section, a creditor or assignee of such beneficiary shall not reach the interest or distribution by the trustee before its receipt by the beneficiary. That's the spendthrift portion that I was just explaining to you.
Right.
It's the asset protection.
So this is the protection part of it. They shall not, and if they do, it's in a violation of the spendthrift.
Yes, it would result, any violation by the beneficiary would be an occasion for piercing the trust, which is basically, that just means destroying it, reaching the assets.
And so what is the penalty for that?
The assets would then be able to be reached by a creditor. They would, the protections of the spendthrift trust go away.
Go away.
Mm-hmm.
Okay, all right, thank you.
Then they call that piercing the veil, I think.
Well, piercing the veil is another term. It's yeah, you're right. Similar.
Well, and you're saying that, I think you mentioned the creditors. If I were to sue you, I can't go make a spendthrift trust.
That's right. If
and
the
put that
assets are
in
not
there,
already in the trust, that is correct.
then they're vulnerable.
Correct.
So you can't just go hide money in it.
That trust would be voided if someone attempted to do that.
Do you have another? No. Okay, yeah, okay, all right.
I have, this is an easy one, maybe in just to kind of put it on the record and maybe help those of us who don't work in, this industry, what the material difference is with this form of trust versus, other typical trusts.
Okay, so the material difference here is that the person who owns the assets can actually create the trust and then also be a beneficiary of the trust. But in doing so, that person loses control over the assets. He cannot control the investments. And he then has to request from the professional trustee any distributions. And he can never take out more than he put in as a distribution. But that's what makes this trust different.
In your mind, what would be a typical scenario that might give rise to this, which to me just kind of sounds like a self-serving living trust, but I can imagine a few scenarios. I just was curious what you thought.
Well, if individuals who want to engage in various business practices, they will enter into agreements, and they'll enter into loan agreements with banks. They will list their assets, or they'll enter into agreements with other individuals, and they'll list their assets as part of the whole due diligence process. Well, those assets that are listed are at risk. And if the person with whom this individual is transacting business doesn't feel comfortable, doesn't feel like it's enough, well, they won't get a business deal. But if they do, and then something does go south with the transaction, then any assets that are in the spendthrift trust will be protected. So that way a person can continue to engage in business transactions without risk of losing his home and everything else that he may own.
So how long could one of these trusts last?
It can last through his death, and he can name beneficiaries.
And the trust still survives for his beneficiaries at that time?
Yes, and remember, there's always another beneficiary as well. It cannot be just for the settlor of the trust.
Yeah, I mean, it's the purpose of the trust could not just be to protect your assets. It could be to protect the assets that you have, your children.
This would be very commonly used in family business transactions. Very commonly used. And in fact, they do exist right now in Georgia, but by Georgia residents, but they're in other states. They're in Tennessee, Mississippi, Nevada, not Georgia. We want to bring them home. We want our money back here.
That's a good point to make, the crux of it. It's not that a Georgian can't do it. It's they just have to go to another state to do it. So that's a good point. Do you have another question?
That's okay. Thank you.
I'll come back to you if you do. Representative Ridley.
I was going to shine a little light on a question you asked about why did Governor Deal veto this. Governor Deal, is an attorney, and a lot of older attorneys, they get set in their ways and they don't want to learn something new. And a lot of older attorneys don't.
Now that he's gone, he can talk like that.
Yeah, that's right. And that was kind of the biggest issue that he had with it, was this was kind of something new coming around. That it's been around for a while, but a lot of places hadn't used it. If you're just an old country attorney, you really don't want to have to learn a whole new deal. And so that was kind of his biggest issue. And I had some older attorneys that was the same thing. They didn't want to have to learn how to do this new stuff, and that was one of the reasons he vetoed it.
And that's Representative Ridley's opinion as disclaimer.
Right.
I did not say that.
I do. Yeah, I understand, and I mean it does. I mean there is folks that have an aversion to an easier way of, and I don't look at it as avoiding debts or avoiding liabilities. I mean it's something that could possibly happen that concerns me. I mean I would think that you know, one advantage, I told somebody after my experience in certain areas, I wouldn't get on a diving board again, because of the liabilities. If your assets were in something like that, you wouldn't be worried about it. Anybody else? Any more? Did you think of another one?
Since these proceedings, I believe, are being recorded, you know, the statements that I read from the governor about this was that he was concerned about the creditor-debtor relationship, you know, and making sure that if people take on debt, that they're able to repay it. I'm, of course, sympathetic to folks who want to be able to save their homes, and I say that as a business owner myself. And I wonder how robust our current protections are. For example, I operate under an LLC. You know, I have the opportunity to obtain business insurance. So that was mostly my question. I understand your point, Chairman, about, you know, this is available in other states.
Yeah, you can do it. I mean, it's
Right.
not like, you know, the creditor is protected more in Georgia because we don't have it. We just don't have the business.
Yeah. So that's why I appreciate this discussion to help me understand. So thank you,
Got it.
Representative
welcome.
Rich.
Any other questions for Representative Rich?
Not a question, I just want to say there's a lot of things that other states allow as well. We can talk about those later. I think we should do.
Okay. Yeah, okay. Anybody else? Any other questions? Representative, I believe you've done a good job explaining the bill.
Thank
and
you.
Thank you, and we'll get back with you on
All right, thank
action
you.
for the bill. Thank you.
Thank you very much.
Okay, at this point, Representative Ridley, I believe, wants to talk about House Bill 490. So at this time, you may proceed, sir.
All right, can I do it from here or you want me?
That's fine. You can do it from right there.
All right, House Bill 490, what this is, this comes with the support of the Georgia Bankers Association and Community Bankers Association. This is already a current law that we're updating. So what happens whenever a person passes away and their account, they're the only person on their checking account, then you have problems getting to their funds in order to pay funeral expenses or any kind of medical expenses, last minute funeral, medical expenses. And so if they don't have somebody on that account, then it takes a little while to get to it, and it could get wrapped up in the probate and in the estate and all that kind of stuff. So this has been going on for years, and basically what we're doing right here, we're updating the affidavit that has not been updated since I think in the 80s. And we've just made 2 changes on the actual law. Currently, you got to wait 90 days. If nobody claims any of the money in 90 days, then you have to wait. Then you can execute this affidavit. So now we're changing that to 45 days. Before the limit was 10,000, we're changing that to 15,000 is the maximum amount that they could turn this affidavit in to pay the funeral expenses or medical expenses with. And that's pretty much what the bill does. And if you look at on line 89, it tells how it's got to go through all the surviving spouse, make sure there's not a will, the children. It goes through all that stuff to protect the family from somebody coming in and just turning in one of these affidavits. And they're the only ones that can actually turn it in order to get the funeral expenses paid or the medical expenses paid. And I'll take any questions.
Representative Moore, do you have your button pushed? And
I
who
have
was
one
first?
burning question for you, Representative Ridley.
I'm not a funeral home owner, no. Go ahead.
Does Representative Bentley support this bill?
Yes, she does.
No further questions.
Mr. Chairman,
Uh-huh.
my question was how many funeral homes, not was he a funeral home? Representative Wrigley, you just said $10,000, but you mean $15,000 that they.
Yeah, I said currently it's 10,000, we're moving it up to $15,000
Okay,
maximum that can be taken
my
out.
question to you is this, so the max that they can take out, so if it's $100,000 in that account, they
Exactly.
can only take that $15,000 out, and then the rest will be up for probate?
Is that?
I mean, that's,
Yeah.
I mean,
Yeah, I
for
think
this
that's what
particular bill.
it says, a maximum of 15,000. Whenever any person dies, having a deposit of not more than 15,000 in the financial institute.
Does
So,
the, I have one more.
okay,
Now, this is in the event that someone comes forward.
comes what?
Forward. You said, this is someone that doesn't have anybody on their, is not a beneficiary, doesn't have anybody on their bank account.
Correct.
Nobody can draw the money out because nobody, this person is deceased and the money is sitting there and we need to pay the bills. Right?
I think that it says you got to go through, like, if they don't have a will, you
I
got to go
see on
through
here
trying to.
brother, sister, spouse,
Yeah, you
father,
got to try to
mother,
find all these people. So, yeah, then if they didn't,
no surviving
no
spouses.
survivors, then, and they did have that account, then you use this affidavit in order to get paid.
And is this for the funeral home?
I'm sorry?
Is this for the funeral home?
It's funeral home and medical expenses. Last minute medical expenses, I think is what it says.
Yeah, but I'm saying the entity that can draw this money, is it a funeral home? Because
Yes.
you don't have a person now, because there's no family,
Right, the funeral home can, with the affidavit, they have to have a
or a medical
itemized
facility.
receipt. Did you ask me another question? I'm sorry.
Yeah, I'm just trying to say, this is not people, these are companies that can come in.
Well, yes. I think I'm telling you, is there anybody in here from the bank in this, Miss Brandy? Are we saying it right, that it's, if they have nobody at all, then the funeral home can file this affidavit, is that right? Yes.
My understanding, this is current law now, that where a funeral home or a medical facility, last care kind of place, can request bonds up to 10 grand, and current law is still 15 grand. So that is current now. They have to wait 90 days. In current law, this still takes up to 45 days, but it does not jump ahead in the family members. And this is in situations where there is no will. So if there's a will, it's payable on that account, this schematic doesn't apply. This is just as a funeral home in a situation where there is no payment, can get some payment out of that particular account. But those family members would still be able to get the funds first within the 45 days if they submit the affidavit. Not the affidavit in the bill, but submit it to the financials.
So I just want some clarity. Any person or entity out there that has a debt against this person, this bill is not for anybody, it's just for funeral
Yes.
and medical.
Yeah. Right.
Not a personal care nursing home that could come back and say, look, you owe us this amount, so it's just for these two?
In current law now, it's for funeral homes and it's for the last medical expenses of the
Okay. Thank you.
Any other questions for Representative Ridley? Okay, thank you for coming. I know everybody's got a busy day. It's been a long day. The most likely scenario that we're going to do is to come back in Monday afternoon and vote on these two bills. So if there are any more questions, get with the author or interested parties and find out what they are. And then if we have more questions, we'll answer them. We'll take however much time we need, but the most likely scenario is going to be a vote on both of these bills Monday afternoon. Okay? Anything else? Thank you. We're adjourned.